thank you for having me this evening. As Shirley indicated, I'm one of your 2 Superior Court judges. In the smaller counties in Arizona, you elect both your Justice of the Peace and your Superior Court judges, so I'm an elected official. The Supreme Court has told me I'm an elected official, but not a politician. So there's a little bit of a difference. It makes when we start running for election, things get a little strange. First, thanks for having me. I work for you. I'm a public servant, so I appreciate all of you paying your taxes and allowing me to serve you. And hopefully when I go to work every day, I remember that and work as hard as I can for you. Before I get into talking about domestic violence in the courts, I just wanted to tell you a little bit about the court system here in Gila County, just in case this is my opportunity to sort of brag on our courts. We have 2 divisions in the Superior Court. Judge Chambers and I are both elected. We have a full-time pro tem, which is Judge Scales. And then we have a commissioner that works part-time and 2 volunteer pro tem judges that help us. For example, I have some administrative meetings tomorrow, so one of my pro tems is going to cover 3 or 4 cases for me. In Payson, next week, I'm actually taking some time off. He'll cover those. So that allows us to keep going calendars year-round, not taking the week off. Well, I get to take the week off, but the calendar doesn't stop. Let me just tell you a little bit about some case numbers. I don't know, I find numbers interesting. If you look at, and these are all approximate numbers. Last year in 2019, we had approximately 610 felony cases filed in the Superior Court. That's misdemeanors go to the Justice Courts or the Magistrate Courts, so those are all felonies. So that's, what does that turn out? That's 12 a week, something like that. And that's countywide. We had about 330 new family law matters. Those are divorces, paternity actions, those type of things. Those are new cases. Family law matters, if you've ever had a family member who's been involved or you've been involved, they keep coming back. So those are just the new ones. So after they figure everything out and then one of them gets a new boyfriend or girlfriend or one moves, they come back and we get to do it all over again, or somebody says you're not following the rules. So we do those. Next one's juvenile matters. We have approximately 250 either dependency matters, which is where Department of Child Safety is involved, or juvenile delinquency matters, which is where kids are committing crimes. 250 new cases in those. As far as civil matters, we have approximately 410 new civil matters in 2019. And some of those could be as simple as if you decide you don't like your name, you go to Superior Court to get your name changed. Okay? I can tell you that gets filed. Most of those, it takes me about 3 minutes, 4 minutes. I look at it. They're signed that they're not pending any felonies. You can offer a reason. You can just say, I really like this new name. And you can get your name changed. So, 3, 4, 5 minutes, boom, they're done. On the other end, we have medical malpractice suits, which take years. If they go to trial, they take weeks and weeks. And it's just sort of a mix. And then approximately 140 probate and guardianship cases. Obviously, probate, you think of that as someone passes away. That's one type. It could be parents getting guardianship grandparents getting guardianship, people getting guardianship for their parents. The other way, it goes both ways as that happens. And then there's a huge ongoing, we have a whole calendar of child support enforcement, and that's one of the big things that Judge Scales does. Every week, he probably has 40 or 50 people on his calendar to make sure they're paying their child support. If you don't pay your child support because you're willfully not doing that, we have a Sheriff Shepard will house you for a little while if need be. Okay? Now, we don't have a debtor's prison. It isn't like, okay, you owe it, you're trying to get a job. It's when you don't pay it, you're able to work, you have a job, and you're just putting everything else before it. The kids need that child support. So, all that together, I think that added up to, I wanted to say about 1,700 new cases. And so there's 3 of us basically that are handling all those cases. So, a couple other updates. As far as facilities, people always ask me what's happening up north. Good news on that front. First, the probation department moved out of the building we're in now. So they're in a different building. I think it's down on Arrow Street, right next to the Catholics.
St. Vincent de Paul.
St. Vincent de Paul, next to that thrift store. And the great thing is the front half is normal probation. The back half is going to be a youth center. You'll hopefully be seeing some news about that. They're going to do a grand opening, trying to find a place where either kids at risk kids that are on probation or just good kids, they can go hang out somewhere instead of being elsewhere. So that's a lot of other counties have done that. It's something that hopefully churches, other groups are doing it too, but there's a need in the community, and so we're doing that. That's allowed us, we're going to have some current space in our building. We're going to be looking at, number one, increasing our security. I remember when I started 25 years ago, there was no security. You just walked in everywhere. Now, at least in Payson, you get wanded, sort of, mostly, hopefully. But we'll have full security where you put your stuff in a little bucket. It goes through the metal detector. You go through the little archway and do all that here. Hopefully we can expand our courtroom just so we can have more room on regular days, and then potentially if we have, recently there was an issue involving the mayor where we had people in another room and the video between the two, and of course our internet is great here in Payson all the way around. And so you got a nice stop-start on the video. So that's happening. The county also is working on putting up a 10,000 square foot building between where the courthouse is now here and the post office. There's that dirt parking area. They've hired a design firm. They've hired a construction company. They're doing some scoping meetings right now. I was at one last week. We told them what our needs are. It's going to be multi-department. 3,000 square foot of that 10,000 is going to be a big room. It'll be used for lots of stuff. When we need it for jury trials, we'll be able to select a jury in Payson and have a trial in Payson. So hopefully when you get your jury summons, it will say show up at 7, I guess it won't be 714, it'll probably be 710 South Beeline Highway or something like that, which will be a good thing. I like that. And we're just going to use that. The Board of Supervisors would use that room so they could have full meetings there. The Planning and Zoning Commission, again, potentially big hearings, and then also community events if there's nothing else happening, and just sort of bringing everybody in. And that building will have security as well, because we take it for granted in courts that we need security. People who are upset about their taxes, the assessor, the treasurer, they're at risk too. And I know Planning and Zoning, all those people. So some great stuff happening there. Keep watching. I've been on the bench 5 years, and for 6 or 8 of that 5 years, we've been working on new facilities. Not really, but I know Judge Cahill was working on it before me. I've seen lots of start-stops. Fingers crossed, I think this one's really moving forward because there's planning, there's things happening, and I think there's money behind it. The county has money set aside. They're building a facility for the dogs on the south side, and we're getting a multi-purpose building up here with the court. So I guess we're the winners. So, okay. So let me do that. Okay, let me start. Going old school with the flip chart. If I start standing in front of the flip chart, let me know. As Shirley said, domestic violence from a court perspective. What is it? What it isn't? And why it matters. And I'm going to talk from the court perspective. Civics lesson. How many branches of government do we have?
3.
Okay. What are they? Legislative. What did the legislature do?
Make laws.
Make laws. What's the second branch? Not my branch. Not my
Executive.
Executive. What does the executive do?
It enforces the law.
Carries out the laws. Third branch, which I'm a part of. Judiciary. What do?
Judge it.
We resolve disputes and say what the law is. Okay. Now, I'm not the only member of the judiciary that's here this evening. You actually have. There's someone else in the room who's a member of the judiciary. Do you know? As of today.
Oh, as of today.
As of today. That's right. You have the chairman of the current grand jury is here.
I know it's grand jury.
And the grand jury is actually part of the judiciary. Okay? They meet in the county attorney's office, but they work for me.
Okay.
So, and
Yeah,
they can get that. So it's just an interesting tweak in our thing. Okay. I am a member of the Federalist Society, and I don't know if any of you have heard that. Okay. I think that the Federalist Society has a great statement about the judiciary, and it is. This is a line, I didn't make this up, this is their line. It's emphatically the providence and duty of the judiciary, or the courts, to say what the law is, not what the law should be.
Yay!
And I'm going to so I try to do that every day as I sit on the bench. I use the discretion the legislature gives me, but I'm bound by what they tell me the law is. And as I go through my presentation tonight, I'm going to sort of rely on that. I'm going to try to tell you what the law is in Arizona, on domestic violence. I'm not going to tell you, hopefully, my personal opinions. At the end of the evening, you'll go, if you had a specific policy question and you ask me, I'm going to say, I'm going to defer. That's not my job. Talk to Brenda or folks that are in the legislature. They're the ones that set the policy as what it is, and as the courts, we implement that. Okay? So I guess that's a good thing, and then I'll tell you that it's also good for me because I can tell if you don't like it, it's not my fault. Okay? So, okay. And I will really try to refrain from editorializing because it's just not appropriate for judges to do that. And again, to give you an overview is my goal. Let me start with that this is an area that's statutory, it's set by statute, and it seems like an area that intuitively you should say, that should be simple. Okay? If I ask somebody what domestic violence is, and I said, you have to just give me like a one sentence, most people would say a man's hitting a woman. I guess that'd probably be the most simple, basic. Okay? But it has lots of technical complexities in the statute. There's criminal aspects. There's different rules or statutory provisions for family law matters. And then there's an area where the federal law sort of gets overlaid. And so we'll talk about each of those. Okay. Let me start with, first, let me ask a question and throw out some scenarios, okay? I don't like to stand up here and lecture. That's not my style. I'm doing okay with the microphone, but I like to walk around. So, let's start with a question. I'm going to give you 4 scenarios, and as I'm talking about these, I want you to think, here's the question. Who can be charged with the crime of domestic violence? Okay? First scenario, a husband and wife, they're separated. The husband goes out and steals the wife's car. Okay? She's at work. He knows he's got his car. They're still married technically, and he goes while she's at work and either hotwires it, uses his set of keys, or just has it towed. Okay? And then while he's doing that, because this is a great separation, the wife is over on social media posting all sorts of horrible things about the husband. Okay? So that's scenario 1. Okay? So again, be thinking about who can be charged with the crime of domestic violence. Next situation. Brother, sister, okay? And they're adults, we'll say. I have a sister who is in her late 40s. I'm in my early 50s. So she comes up. My wife and I go to California for a couple days to a quilt show. We come home, and she's broken into my house and just use it as a staycation for a couple days. So she's trespassing in my house. Okay, scenario 2. Scenario 3, a parent and child. Let's say for this one we have a parent. The child, let's say, is a middle schooler. The parent, and like most middle schoolers, they really love their parents all the time, right? No. Okay, they come home. Middle schooler says, I really want to go out with my friends on Tuesday night and see a midnight movie. The rational parent says, that's probably not a good thing to do on a Tuesday night since it's school. And the kid gets really upset and just takes a key or something and runs it right down the side of their parent's car. Okay?
Yeah.
Hopefully that never happened to you, Andy. Okay?
No.
Okay. Okay. Last scenario. This is the old high school flame scenario, okay? You come back for the 20-year reunion. Okay, your 20-year reunion. Someone who dated, you have a couple that dated in high school 20 years ago. She comes up and slaps him after he makes some really off-color comments. Okay? So, let me just ask, so those things, who of those group can be charged with the crime of domestic violence?
Number 4.
Okay, just a second. Let's go to one table. I do this when I do jury selection. I say, okay, this group first. Anybody here want to weigh in? Number 4. You think number 4? Okay. Okay. Anybody else on this side want to weigh in? Just a second. I'll come to you in a minute. You're good. Okay. Anybody in the middle? Who thinks here? Yes. Number 3. Number 3. Okay. Anybody else in the middle want to weigh in?
I would say none of them.
Okay. You're going to say none of them. Okay. How about over here?
I would say all of them.
Shirley's going to say all of them. Okay.
In different aspects.
No.
Okay. Andy, what are you going to say?
That middle school kid.
Do you think the middle school kid?
Yes.
Okay, just because it's a middle school kid.
So he's automatically guilty.
Okay, there you go, because he's a kid. There you go. Okay. Don, did you want to weigh in? Did you want to weigh in? Who did you
I would
think?
say no, none of them,
Okay. Okay. Why don't you think any of them?
because there's no physical contact between any of them.
Okay.
The
Slap,
slap
slap.
their boyfriend, but
Slap.
they're not related.
Okay. The answer to this question, who can be charged with the crime of domestic violence, is none of them. Okay? Now, the reason is, if you go look in the Arizona Revised Statutes and you try to find the crime of domestic violence, you will be looking a long, long, long time. Okay? There isn't a substantive crime of domestic violence. Okay? The way the criminal statutes work is you define conduct, and then you say that conduct has a certain punishment. So you say, shoplifting is defined as if you remove something from the immediate display area, and one of the ways you can do it is you pass all points of sale, and you don't pay for it with the intent to leave without paying for it. Okay? That's how you define shoplifting. Then the next part of the statute says, shoplifting is a class 1 misdemeanor. Now, if you have 2 prior shoplifts within X number of times, it can be a class 4 felony. If you use an artifice or device or something, it can be another class 4 felony. But so you define conduct, and you say that conduct has this punishment. Okay? Arizona Revised Statutes define domestic violence, but then it doesn't say domestic violence is this class of offense. Okay? So let's change the question, though. Let's do this. Hope this will work. Okay. Now let's take the question, who has committed an act of domestic violence? Okay. Does that change any of your minds? You probably, and this is how technical it can become. Okay. The goal here isn't to confuse you, but to try to sort of get into why some of these things happen in the court system way. Okay. Now, an act of domestic violence is defined in statute. Okay. And what it does is it takes a certain group of crimes and it says they are domestic violence offenses. So it's basically, the way I describe it is domestic violence is a way of categorizing crimes. So you have to find an underlying crime, and then you say, does it qualify as an act of domestic violence? Okay?
Kind of like hate crimes.
That's a great example. Although I'm not sure, is the opposite of hate crime a love crime? I was wondering that.
Those crimes.
So what you do, 133601 gives you a whole list of crimes, and then a whole list of relationships. And if you can find the crime on the left and the relationship between the victim and the perpetrator on the right, it's designated domestic violence. Okay? So some of the things on the left, pretty obvious. Homicide, that makes sense. Assault, someone said that, it's an assault or a battery. Arizona doesn't use the word battery, we just use assault. Kidnapping, sexual offenses, stalking, that's probably one, if I ask you for a domestic violence offense, that's one that pops up in your mind. Trespass or burglary, disorderly conduct, criminal damage, cruelty to animals, can be a domestic violence offense, violation of a court order, or child abuse or adult abuse. Okay, so you have to say, is there a crime over here? And then you say, okay, now is there a relationship between the two people? So the relationship, the first one is one that's pretty simple. And the relationships, I can tell you, in 25 years, they keep getting bigger and bigger and expanding. Okay? And part of that is the legislature decides those, and there's probably good reasons for them, except it gets, got to be careful, because sometimes you get things so expansive that it loses some of its meaning. Okay? So marriage or former marriage, that's an easy one. Okay? You can look, were they married or are they married? Okay? Resided with or resides with, that's one that always is a real tough one to find out, because resides with, if you look it up in a legal dictionary, it says basically you reside together, or you live to reside. You reside means sort of living together as a family. Okay? So and what does that mean? So if you have two folks, Arizona doesn't have common law marriage, but if people live like a common law marriage, that's residing together. The thing that always comes up is what happens if I have a 3-bedroom house and I rent it out to two guys who just pay me, $400 a month to use their room and their bathroom. That's a tough one. I would say probably that's more of a business relationship. Okay? What happens if I rent out that room to a family member? It may look a little different. When this first came out, and even today, some people will say, if you're college roommates with somebody, you resided with them. That's a tough one, because you know what? Some college roommates probably lived like a sibling. That's the relationship. Others of them happen to be in the same dorm room, and you almost have an imaginary line down the middle, which is don't come on my side, don't come on your side. Okay? That's not residing together. Another one is one is pregnant by the other. That's another one that's pretty easy to determine. You can just a little science there. Other ones are just blood relationships, parent, grandparent, child, grandchild, brother-in-law, or sister-in-law, or parents-in-law. Okay? So again, these are getting expanded out. Another one is, and those can be either blood or by legally. So if you adopt a child, that child is your child, not by blood, but by court order. Also, if I'm married, my wife's, if she has an adopted brother, he is now my brother-in-law. And some of these just get a little, maybe a little repetitive. The victim is a child who resided in the household with the defendant. That sort of sounds to me like resided together, but there's a separate section for that. A lot of times I think folks who don't think they got their fair shake in court, they go to the legislature and they say, we need this specific provision. And if you look like in our theft statutes, we have general theft, we have shoplifting, we have theft of a rental truck, we have theft of a video, we have theft of everything in the world. So the last one, which becomes the most broad, is a current or prior romantic or sexual relationship. And so that's one that's really, what does that mean? Does that mean, and that's ultimately, it's the trier of fact. So if it goes to a jury, you tell a jury, here's the factors you consider. Did two people that walked through the park one day holding hands, did they have a prior romantic or sexual relationship? It's up to the trier of fact. Okay? So let's go back to these scenarios. Go back.
You've used that a lot, haven't you?
Okay, so first one, husband and wife. First of all, if one or the other is a victim of the crime of the other, they're going to fall under the right side relationship, right? So there's not the problem there. Husband stealing the car. Okay. Was theft on the left side of that chart?
Yeah.
Yep.
Where's theft at?
Stealing. Oh, no, wait.
It's not on there.
It's not on there.
Theft is not one of the
Stalking.
domestic violence charges. So now, prosecutors can become very, very creative when they charge, but you look at what they're charged with. Okay? Now, if he had to stake out the car before he stole it, he might have stalked her in the second act. Okay?
Well,
But generally, theft is not a domestic violence offense. It can't be, because it can't fall in.
Could be a
Took it out of
violation
the
of court
garage,
order
then that's
if they
burglary.
had
If
it.
you took it out of the garage, you're right, that would be burglary, because that's entering a structure with the intent to commit a felony therein, or theft. So if he stole the car, that's good. If he stole the car out of her garage, or out of a fenced yard, then it could be a domestic violence offense if they charged it as burglary. Okay? How about,
so that's the police charge him?
the police are going to make the initial arrest, but ultimately it's going to be the prosecutor who looks at it, and ultimately on a felony, it's probably going to be the grand jury who makes that determination.
Oh, okay.
Now, grand jury, they are, how many, are there 18 of you? No, 26.
There are 20 chosen.
And 6 extras.
And 14, 16 regulars and 4
Alternates. Okay. So those folks, they're going to make the decision legally. Now, those are 16 folks who are just like you. They have a day or two of training in the beginning, so they're going to be relying on. They don't get recommendations from the county attorney's office what to charge, but they do get a form of indictment presented to them just for their convenience if they want to use it. Okay, and they're free to change it or do whatever, but in reality they are relying on those some. But they make those decisions, and if it was presented to them and they said the charge was theft, a grand juror could raise his or her hand and say, "Wasn't it burglary? Didn't he steal it out of the garage?" And then the county attorney who's assisting them can provide a legal opinion, but again, it's all to the grand jury what they do. So the first one, As stated here, probably not a domestic, not an act of domestic violence under Arizona criminal statute. How about the wife posting all sorts of horrible things on social media?
No.
Generally under the First Amendment, you can do a lot of really nasty, mean things, and our criminal law isn't designed to keep people being nice. I mean, hopefully that's a social compact we have where people are nice. Okay? How about the second one? Brother or sister, the sister is trespassing in the brother's house. Okay, is there a crime on the left side?
Yes.
Trespass.
Is there a relationship on the right side?
Yes.
Okay, so that is an act of domestic violence, the second one. Okay. Third one, a child keys his parents' car. Okay, is there a crime on the left side?
Criminal damage.
Criminal damage. If you recklessly damage the property of another person, the child has done that. Is there a relationship on the right?
Parent.
Parent or child, right? They probably reside together. We can find 2 or 3 that they fit into. So, the third one, an act of domestic violence.
I knew it.
Good, you knew it. Good job. Okay. And I have to admit, my original question, I intentionally made it tricky, okay? Because it's boring if I just ask you the question. It's easy to answer. So, okay, how about the last one? Old high school flame, she slaps him after he makes an off-color comment.
He's in trouble.
Okay, what do you think? Is there a
Yes.
crime there? What's the crime?
Assault.
Okay, assault. Assault can be committed 3 basic ways in Arizona. You can touch someone with the intent to injure, insult, or provoke them. You can cause physical injury, or you can place them in reasonable apprehension. If she gave him a bruise, that'd be 1. If she did it to insult him, that's an assault as well. Okay? And then the relationship, the question there becomes, what was it really like back in the day? You know, back in the day, was it 20 years ago we didn't text. We just, exchanged notes in class. That may or may not be a prior romantic relationship. But if back in the day they were hot and heavy, and in fact they even had a kid during high school, then that becomes an act of domestic violence. Yes, question?
Would it be for the trier of fact to decide whether there was enough of a relationship during the intervening period? In other words, if neither one of them was stalking the other one, or neither one of them were having any kind of a relationship for 20 years.
Yes, and there is, if under all of these basically just say, here's what it is. This last one, it says it's a current or prior romantic or sexual relationship, and you can use these 4 or 5 factors plus any other factor you want to determine whether that exists. Now, the trier of fact is going to do that for every one of these, but that one is specifically, it says, and I think one of the specific things is the length of time since that, which is sort of a strange thing, because they either did or it didn't, and then it should say it has to be within a reasonable time, but it's the legislative council must have written it not the way you asked them to. So, and you also have to remember that all of these statutes, in the legislature, you have 60 in the House, 30 in the Senate, right? So you have to get 45 members that agree on language. So a lot of times, no matter, even if a group comes to the legislature and says, this is what we want our language to be, it can be tweaked through the process. Now, they have lawyers at the legislative council who are writing it so that it's as clear as it can be, but ultimately, it's the legislature who decides what the language is going to be. So, okay. So, yes. Okay, yes.
The relationship between the civil court and the criminal court, these would be civil complaints?
These are all criminal so far. That's all I'm talking about.
Criminal.
Yes.
I see.
Okay, this is in the criminal context. Again, there's not a crime. You can't get charged with the crime of domestic violence. Okay? So let's go back to, let's take this one. I think this was one of the simpler ones, the parents or the child. Okay? Let's say the child is 18. The child, he keys his mom's car, and let's say there's $1,000 in damage, which probably isn't that hard to do. Okay? So that's going to make it a felony. So he could be charged with criminal damage because of that, and then typically it would have a domestic violence allegation attached to it. So the underlying criminal code would be 1602A1, which is criminal damage, and then it would say, and it's a domestic violence offense under 133601. Okay? So those are the so that's how it would be charged. This one, if it is, it could be an assault, under 13-1202A3, which is if you touch someone with the intent to injure, insult, or provoke, / domestic violence, and then it would cite the 133601A section. Okay? So the next question is, so what? Why does it matter, right? Okay? There are some, let me just make sure I haven't skipped anything in my notes. Oh, one more wrinkle before we get to what it matters. There is a crime in Arizona called aggravated domestic violence. Okay? Aggravated domestic violence is a felony. The way you commit aggravated domestic violence, you have to do three things. First, you have to commit a crime. So again, you have to find a crime. Aggravated domestic violence, it has any crime. Okay? And the second thing is you're going to have it be categorized as domestic violence. And the third thing is you're going to have 2 prior convictions, misdemeanors or felonies, that have a domestic violence tag as well. Okay? And we'll get to that in a few minutes. Remind me, I have a great example of what can happen on that type of thing. So, no crime of domestic violence, there is a crime of aggravated domestic violence. Okay, so what? Why does it matter? And these I will go through. Okay, here we go. Let's see. Okay, we'll start off with some of the really important ones at the beginning, and then first, if you're convicted of any crime that involves an act of domestic violence, and you plead guilty to that in Arizona, whether it's a class 3 misdemeanor, which is the lowest, whether it's a first-degree murder charge, which is the highest, either way, you have to attend domestic violence counseling. Okay? It has to be a certified program. Right now, it's at least 26 sessions, and you get to pay for it. So if I go home and slap my wife, one of the things I'm going to get to do for the next 26 weeks is go... this is only in the court setting. I'm not discussing reality. Okay? I get to go attend domestic violence classes. Okay? So I do that. I'm going to the classes. Okay? Andy goes home, and I'm going to use Andy as an example because I know he wouldn't. He goes home and plots ahead of time, pays someone to kill his wife. Okay, poor Patty. He gets convicted of first-degree murder with a domestic violence allegation. He and I could be sitting in the same class because the class is the same. Anytime it's a domestic violence offense, you've got to do the classes. Now, Andy's probably going to do his in prison. He may actually go, I'm in prison for life, I don't care, I'm blowing off the classes. I would probably do mine because I'm hopefully an upstanding citizen. They're not cheap. You're going to pay probably $100 to $200 a shot for these things.
Wow.
If you have good insurance, you may be able to get them otherwise. Your insurance, under the mental health part of it, may pay for them. That's one of the consequences. Okay. And again, these are things the legislature has said. Again, I'll let you determine whether you think it's a good requirement, a bad requirement, if it's sometimes a good requirement. The first time, the judge has to impose it. If it's a second or more domestic violence, the judge has to impose it unless the judge determines it either wouldn't be helpful or it's not appropriate. So the idea is, I think the idea behind that is if you've done it once, sending you back again, it's probably compulsory attendance instead of you're learning anything. Okay? Second thing you have to do, there's some various assessments. Any domestic violence offense, you're going to be paying an extra $50 on your conviction for the address confidentiality program. You're going to pay $50 for the domestic violence services fund assessment. So again, Andy's convicted of first-degree murder, domestic violence. I'm convicted of a class 3 misdemeanor, domestic violence. We're both going to get tacked on $50 for each of those programs.
Only fair.
Only fair. Andy probably won't pay his because at $2 a day or whatever it is in prison, he's not going to have that much money. So, okay. Second thing, this is the state restriction on firearms. Okay, if you are a convicted felon in the state of Arizona, you can't possess a gun. Okay, I think that's one of those things that most folks would say they agree with that. If you go to the Heller decision, the U.S. Supreme Court, Justice Scalia, who is not a fan of gun control, he said that the government can impose reasonable restrictions. One of the things he cited was felons and guns. Okay?
Question though.
Yes.
That little kid that threw a tissy fit and scratched his mom's car, and it's a felony, he can never own a gun?
Well, now that's going to be, if it's a juvenile offense, it may go away at some point. If he's 18, it's a felony. As long as that remains in place, he can't. Now, there's a process to have your rights restored, including your right to possess a firearm. So you can have it set aside, and he can get his right to possess a firearm back.
And your right to vote.
Your right to vote, typically your right to vote, your right to participate in a jury, and your right to have a gun. Okay. So felony, that's a general rule. If you are on probation for, and also a standard term of probation in Arizona is that you don't possess a firearm. If you're on probation for a domestic violence offense, even if it's a misdemeanor, you cannot possess a firearm. So again, I slapped my wife, class 3 misdemeanor, the lowest possible, maximum 30 days in jail, $500, $250 fine, 1 year probation. If the judge says, Tim, you're on probation for a class 3 misdemeanor, if it's a domestic violence offense, I can't possess a gun because it has the domestic violence tag. Okay? Third one. This is Brady. Okay? There's a federal restriction on firearms that if you have, and federal law says you are a prohibited possessor, i.e. you can't have a gun, if you have a misdemeanor conviction for a crime of domestic violence, okay, and it doesn't matter, when this first came out in 96 is when it first came through the pipe, all of a sudden all these men, primarily men back in 96, a few women, that were law enforcement officers that had a domestic violence offense from 5 or 10 years before went,
Bang.
I can't have a gun, I can't show up for work, what am I supposed to do? So that was the
They're
thing.
biggest abusers.
Okay? Now, it gets more complicated there because the federal statute says you can't do it if it's a crime of domestic violence. Statutes are great at defining things, and of course, state law and federal law don't define the crime of domestic violence the same. So, a lot of these things that we went back here, the kid key in the car, under the federal law, it has to have an element as the use or attempted use of physical force. So that means the kid who keyed the car, he or she's out under the federal law, and was committed by a current former spouse, parent, guardian, having a child in common, cohabitating, etc. So their crime list is a lot smaller, and the relationship list is a lot smaller. But that doesn't help folks. And the federal law doesn't say that your misdemeanor crime of domestic violence have to explicitly say that in your conviction. So let's say that I go out, I slap my wife, they charge me with assault, domestic violence, and I have a really good lawyer, and I beg and plead, and I'm a nice guy, and all I plead to is just simple assault. They dismiss the domestic violence allegation. Okay? Under federal law, I've pled to a misdemeanor crime that had an element, the use or attempted use of physical force, and the crime was committed against my spouse. So I'm not giving you legal advice, but there's a very good argument that that misdemeanor conviction, even though it doesn't say domestic violence on it, prohibits me from possessing a firearm under federal law. Now, at the same time, I can go out and fall into one of those categories, let's say an old girlfriend. I plead to a state charge that's assault with the domestic violence allegation, but because the relationships are different under federal law, I might not be a federal prohibited possessor. So, yes?
Under what conditions would domestic violence be a federal offense?
It's not a federal offense. What it is, and the way it gets used typically is you're doing something else and you have a gun, and they go, oh, you have a domestic violence offense in your past. Federal firearms charges usually run around 5 years, around 60 months in prison. So we can't get you for tax evasion, or we can't get you for this, but you had a gun, it was yours, and 12 years ago you beat your wife. How about if you just plead to that and you can do 5 years? So, now, the reality is the feds don't have the person, they're not out checking everybody's ID, running criminal histories and stuff.
Oh, yes, they are.
Well,
So, the federal law is not applied in the state courts.
Correct.
You have to go through a federal court system.
Right.
So you have to be arrested by the marshals or something like
but
that.
you could theoretically be arrested by anyone, you would just have to be charged by the U.S. Attorney's Office.
Okay, that's, okay.
Yeah, so
Right.
Sheriff Shepard could arrest me for, let's say that I really beat up my wife,
But
really bad
there's a
again.
choice in there
Right,
on whether you use the federal courts or keep it in the state court.
yeah, let's say that I really beat up my wife bad, but either my wife dies or the state officials say, we can't prosecute this. They can call up their buddies down at the U.S. Attorney's Office and say, hey, we can't get Tim for what he did now, but we know he has 3 or 4 guns in his closet, and 2 years ago he did the same thing, so why don't you just send him to prison for having the gun today, because you can't get him on the other stuff.
So why would that, how could that occur? If something like that had occurred, how was it you couldn't prosecute through the state courts?
Let's say that,
But the federal courts could.
well, but they prosecute for different things. The state
Oh,
court,
I see.
in other words, me beating up my wife the new time, she's a very convincing witness, and she says it was all her fault, or a burglar broke into our house or something. Whereas the gun charges, or weapons misconduct, are some of the easiest charges.
Of course.
You tell a jury, he had a gun, and he beats his wife.
Yeah.
Okay?
Red
Or
light.
he has a gun, and he's a prior felon. I mean, those are not, in some ways, those are dream charges for prosecutors
Yeah.
because, and typically the person who's sitting at the defendant table doesn't look like me with the tie on. Okay? If I'm sitting at the defense table and they say, he had a gun, he has a prior felony, and he beat his wife, and I have a face tattoo, the reality is you're going to look at it different. So, okay. So, yes.
What's the monetary limit of a felony and a misdemeanor?
Misdemeanor in Arizona, class 3, $250 fine plus surcharges.
Not the fine, the damage somebody does.
Um,
Being charged with a
I
misdemeanor.
mean, for criminal damage,
Yeah.
I think that they charged them recently. They changed them recently, excuse me. When I was a prosecutor 20 years ago, $250 was where it went from a misdemeanor to a felony. I think today it's $1,000. And then it goes up, as you go up, the level of felony increases as well. I can tell you it'll be 1602,
Isn't there 3 levels?
1602A.
3 levels on the misdemeanor.
Yeah, 3 levels of misdemeanor, class 3, 2, and 1. And it used to be that anything under, I think it still is, under 1,000 is a class 2 misdemeanor, and then anything over that becomes a class 6 felony, and then goes up from there depending on the value. And it works for that, for criminal damage and for theft, works sort of the same way, same thing. Yes, in the back, very back.
Slight side issue. Can you explain the difference between assault and aggravated assault?
Yes. Well, assault and aggravated assault, that's one where there is 2 statutes. There's a statute that says assault is you either touch someone with the intent to injure, insult, or provoke them, you cause physical injury to them, recklessly or knowingly or intentionally, or third is you place them in reasonable apprehension. That becomes an assault. If you do an assault under certain circumstances or with a certain victim, it goes up and becomes an aggravated assault. The misdemeanor assault statute has been the same for the last 30 or 40 years. Every 4 or 5 years, the legislature adds another subsection to the aggravated assault statute. Okay? Traditionally, it's been if you used a gun, dangerous weapon, deadly instrument, if you broke a body part, a bone, if you caused serious physical injury. Then they added in police officers, then they added in prosecutors, then they added in judges, then they added in, not all these are in the right order, they added in teachers, they added in nurses, they added in firefighters and paramedics.
Protected class.
Yeah. If someone's ability to resist is impaired, that can be an aggravated assault. All of those things happen. And then as you look at the penalties, sometimes you combine them. If you use a gun on one of those people, it's higher than if you use a gun on someone who's not in one of those, or if you assault them but don't use a gun, and it goes all, that's a really long statute, and if you're interested, you got to read it about 4 times and outline it, and then you'll figure it out. So, okay. So federal firearms restrictions. Now, the last different consequence is the aggravated domestic violence charge that you can be. Normally, domestic violence doesn't change the category of the crime. So if it's a class 3 misdemeanor, it's class 3 misdemeanor domestic violence. If it's first-degree murder, it's first-degree murder. If it's a class 1 felony, domestic violence. If you have aggravated domestic violence, it's a class 5 felony, no matter what the underlying offense is. So again, if they're saying, if someone chooses to charge Andy for, let's say Andy has 2 prior domestic violence offenses, he murders his wife, and they say, aha, we're going to go after him for aggravated domestic violence. He committed an act that was domestic violence this time, and he has 2 prior domestic violence convictions. Class 5 felony is what he's charged with. Okay? Me, I slap my wife, crime that falls under the domestic violence category, and if I have 2 priors, I've been charged with a class 5 felony. Okay? because it's a third domestic violence offense, is a Class 5 felony. So it can give you some strange, hopefully you're seeing some of the strange results you see there. So it really can, now practically, if they're going to do, in Andy's case, they might charge Andy with murder and aggravated domestic violence. That's why in case a jury for some reason said, we're not convinced that Andy did the murder, but we're convinced that he at least hit her or something, then they would at least come away with something. But here's what can happen. So I've had a real case. The guy's name is Steerley. It was a trial. He had a trial. Charged with several counts of aggravated domestic violence. Okay. Goes over to his mother-in-law's house, where I think his girlfriend, it's been several years since I presided over the trial. His girlfriend lives there, or they're doing some work there. At some point, there's a scuffle in the house, and he gets mad, and what the jury finally finds, is that he pushed the girlfriend, caused her to fall down. Okay? If I go up to Shirley's sitting there, and I push her to the floor, and she doesn't get any bruises, she doesn't break her arm because she hits the chair funny or anything, that's normally a Class 3 misdemeanor. Okay, I can get 30 days in jail, $250 fine, up to 1 year probation. Okay? So, but this is a case where he had two prior domestic violence convictions that were misdemeanors. So now that push went from a Class 1 misdemeanor, Class 3 misdemeanor, the lowest, to a Class 5 felony. And, of course, these always, and he just happened to have a couple of prior felonies. Okay, so if you have a prior felony, you're mandatory prison. So if you get convicted of a Class 5 felony and you have 2 priors, the presumptive is 5 years, the minimum is 4, the maximum is 6, the mitigated minimum is 3, the aggravated maximum is 7.5 years. Okay? So he went from 30 days in jail as the maximum to 3 years in prison as the minimum. The underlying conduct this particular time, now you can argue he's going to prison not because of what he did at this time, it's going to prison for a cumulative everything. But that aggravated domestic violence, I can't remember if he had 1 or 2 prior felonies. He went to prison. He's still in prison right now. Okay? Those are the kind of cases, as a judge, I'm saying, okay, what do I do? I've had a couple of those where you have a misdemeanor because of the sentencing enhancements gets bumped up. On those, I tend to look, unless they're super aggravators, I'm looking at the bottom of the range. And those are the very few times when I give someone the mitigated minimum. That might be one where I say, shoving your girlfriend, even with that history, 3 years is probably enough in that case. Okay? Off subject, I had a guy, he just filed some paperwork this week, stole a 6-pack of beer up at Giant, up by Home Depot. Got charged with shoplifting, 2 priors. You become 2 prior shoplifting, becomes a Class 4. He has 2 priors. So I gave him the mitigated minimum of about 3.5 years. He only got to drink 2 of them too because they caught him. And when he wrote his latest motion, he said, and he put that in the motion. I only got to drink 2 or 3 of them. So, but even if the case I was just talking about, even if there's no prior felonies, an aggravated domestic violence offense, Class 5 felony, has a minimum of 4 months jail. Okay? So it has. The penalties go up substantially. That first one, misdemeanor, you're probably looking at a fine in your classes. Second one, you're probably looking at fine, classes, maybe a couple days in jail. Third one, as long as you kept them at misdemeanors before, you can get away with 4 months in jail. You get another one, you're going to prison with the prior felony. And so it goes up really, really quick. Okay. That's a summary of the criminal context. Okay. So again, things I think are important is, number one, there is not a crime of domestic violence. It's a way of categorizing crimes. Okay. And when I was a prosecutor and the town attorney, I used to teach prosecutors and cops, and I would tell them, when you show up at a scene, you may get dispatched to a domestic. When you get there, though, think of underlying crime, because cops shouldn't be arresting people for domestic violence. They should be arresting them for assaulting the spouse, committing criminal damage, trespass, stalking, and then add in the domestic violence allegation. Yes?
Before you leave consequences, in your personal experience and assessment, without editorializing, Does counseling make a difference?
That's one, you need to talk to counselors and people who are involved in this area. I don't know.
But you're seeing
Uh,
the same people come back to you
And
who
but-
have been through counseling.
And I don't know, number one, we don't always know whether they actually completed their counseling. Number two, we don't know the quality of the counseling. And number three, we don't know whether they participated in the counseling. Okay? It might be, someone comes to you, comes and says, I've been going to AA meetings, okay? I'm going to tell you, I think generally AA meetings are great. But I think there's probably a difference between somebody who shows up every day at their AA meeting and someone who shows up once a month. There's probably a difference between the person who participates in the AA meeting and the one who sits in the back room, drinks the coffee, and eats the donuts. And there's probably people who do all the right stuff who end up falling off the wagon. There's probably people who do all the wrong stuff, and it never may have been quite as big of an issue for them. So I don't know. That's something you have to talk to the sociologists and things. You've seen how broad the definition is. And it's going to be hard to get good studies, I think, because the definition is so broad. Because there is, the narrow definition of domestic violence, they'll tell you there's a cycle that the perpetrator goes through. But I'm not sure that every crime that has a domestic violence allegation is one of those perpetrators going through that. Because I think all of us lose control at some point. I can tell you, if you drink or use drugs, the point at which you lose control is probably substantially lower than if you don't drink or use drugs. And a lot of times, when you're drinking or using drugs, you're not in your right mind. So I'm not sure the control is you shouldn't have had the first or second drink, or you shouldn't have smoked the dope or shot the heroin or whatever. And beyond that, you're under the control of the drug. So I don't know. Okay, just a second. I'm going to go to the back first, and then I'll come to you, Brendan. Yeah.
How prevalent is domestic violence charges? I listen to the police standards, and I'm hearing them all the time. So how would you say prevalent they are compared to, say, dealing with one of the no crimes?
I think the studies will all say that domestic violence is one of those things that crosses all socioeconomic lines. Okay? Now, the reality is, if you live in a community where everybody lives on an acre lot, domestic violence is probably occurring there. If you live in an apartment complex where everybody has a 500 square foot apartment, it's happening there. Where are the neighbors going to know where it's happening? Probably in the apartment complex.
Yeah.
Okay? So there's a question of how much is happening, how much is getting reported, and then how much is what's happening after that. And you'll see lots of things where, again, a common thing for a dispatcher is to say, I'm dispatching officer or deputy to a domestic. What does that mean? That probably means there's two people in a house that may have one of those relationships, that there's some incident. A lot of those, they may show up and they may say, you know what, what's happening here? And they both say, you know what, we're a little heated. One of us or both of us may have raised our voices. We're okay. And those are tough calls for officers, what they're going to do there. I would say the case where they show up at the house and one of them is beaten to a pulp, fortunately, I think, are relatively few. Okay? As far as the arrests, you read the newspaper. For the arrests, you can read the newspaper for the convictions. May or may not match. In the felony court context, because most of these are misdemeanors, until you get your third one, or until you're murdering, or until those, we don't get a lot of them. I mean, the majority of our caseload is substance abuse in some category. But a mom, let's say a mom's strung out on her drugs and is abusing her kids. Child abuse was on that list. A mom and a kid is in the relationship. So the county attorney's office, when they charge, or the grand jury, they can say it's a class 4 felony with a domestic violence allegation. Now, and those are the kind of things you have to ask the counseling. Is it going to do that mom any good to go sit in the meetings with the 4 guys who just pummel their wives twice a week? Maybe, maybe not, but the classes are the same regardless of the relationship. Because, and in Payson, there's not that many options. So, Brenda, you were next.
I was interested in the fact that you said that the counseling, there's no follow-up, there's no, you don't know whether they win or whether they didn't.
Well,
But
go ahead. Sorry.
If it's a statute requirement and or court ordered, you know if they pay the fee,
Right.
so, you know.
Judge Little or Judge Reardon will probably know where they're staffed. Most of those are going on misdemeanors. By the time they get to me, it's felonies, and it's escalated. I don't have information on whether they attended or not. I guess that's, and maybe I was unclear.
Okay, so is that just a communication gap in there, or is it irrelevant to what you're going to be dealing
It's,
with?
usually it's not irrelevant, but it's not the most important thing. Because whether they went to the counseling or not doesn't matter whether they did the crime or not. It's not, okay, if you went to the counseling, it's only a class 6 felony, but if you didn't, it's class 3.
Yeah.
We might consider that as a sentencing aggravator, maybe not though.
Yeah. Is there something that the grand jury would be interested in, leading up to maybe this higher incident that has occurred?
Probably not.
We've already tried to do counseling, we've done these things, blah, 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 and it's escalating.
Grand jury, probably not, because again, it's not legally relevant to whether they did. Grand jury is just saying, did they probably do it or not?
Yeah, right.
When we get to sentencing, then we've determined they did it, they admitted it, they've been found guilty.
Yeah.
Now what are we going to do? Then it becomes relevant. Normally, we try to keep things that can bias the grand jury. We want them to say, did they do it, didn't they do it? Not, are they a good person? You know, if they did it, but they're a good person, we'll let them off. They're a bad person, we don't think they did it, but they sure they did something else. We keep that away from the grand jury. Generally, if they have prior felonies, the grand jury, they're either not told, or if it slips in, they'll, I'm sure you've heard it, you've heard something, you may not consider it for this case.
Exactly. Right.
And we trust that they obey.
Absolutely.
Okay, Shirley.
All right, so you gave 3 definitions of assault.
Uh-huh.
Physical assault, was it?
Touch with the intent to injure, insult, or provoke, think slap.
Yeah.
Place someone in reasonable apprehension,
Fear.
I'm gonna punch you, I don't have to punch you. And the third one is to cause physical injury, a bruise, a broken arm, a broken blood vessel.
Okay, so then
Broken fingernail.
where does,
Seriously, that would qualify.
so much of what we're hearing now, especially with young people in school and all this kind of stuff, is bullying, and all of a sudden the kid punches the bully back, and then who's the victim? The victim is the guy that gets arrested
Right.
because the bully gets away. So where does all this play in domestic violence when one of the first things you said was the wife was on social media basically bullying her husband?
And
So
right,
what category does that fall in?
hopefully, I think right now, hopefully our social compact allows us to resolve that not in a criminal fashion.
Okay.
I like to tell people, not every wrong that people that a person does, necessarily needs a criminal consequence.
Yeah,
Got it right.
I mean, you hear people, they say, he mentally abuses me, he
Right.
emotionally abuses me, okay? Those are not criminal acts, for the most part. I mean, now if you're really creative, maybe you can get there, but they're still wrong. And so, and I don't think, and this is something, again, the legislature decides what the crimes are. Now, they're bound by what's in the U.S. Constitution. Brenda and everyone down at the Dome can't say, Tim can't write mean letters to the newspaper,
right.
okay? Now, there's a case right now that the Supreme Court just yesterday said they're not going to review. A gal was convicted of either facilitating a murder. She basically, her boyfriend or whoever was saying, I'm going to kill myself, I'm going to kill myself. And she, as he's saying that, he's texting her saying, go for it.
Yeah, go for
Do
it.
it.
Go for it. Yeah.
Okay? She actually, that prosecutor and that jury found her guilty of a criminal offense. And she went up to the U.S. Supreme Court and said, wait, I have freedom of expression, I have freedom of speech. Those are tough situations. All I can tell you is what the law is now. Basically, general rule is words are not crimes, and generally you can't retaliate against just words. Now, if the words are something that would so clearly incite an immediate physical response, then it could be disorderly or things. I mean, there's cases where people get out of their car and start cussing at the cop, and they've tried to say, that's a crime. Well, unless it's going to incite immediate violence, most of the time it's not.
Yeah.
But hopefully we have a social compact where we treat each other at least somewhat respectfully.
Yeah.
Okay, Michelle.
I have a question about why, I've read some orders of protection that are civil, part of the divorce, that scared the heck out of me because of what they did to this family. And I've read the case where there were 2 or 3 divorces, and when I read the orders of protection, there's 2 or 3 civil cases. They all, to me, rise to the level of the domestic violence criminal conviction, but but they were never called, the wife or the partner never called or never stepped out of that civil case. And so, what do you do when you get somebody who, you read this stuff and you just say, oh my gosh, this is all civil and we can't do anything if they didn't move it into criminal? I mean, when does the wife or the person decide?
Well, this all so far has been criminal, okay? There's two other areas that, and hopefully I'll answer your question, but let me just take a side. Two other areas where domestic violence specifically applies. In family law, if you've committed an act of domestic violence, there are some presumptions against you not having legal decision-making for your kids. If it's been serious domestic violence, then you can't have legal decision-making for your kids. And of course, those have different definitions, and these definitions here. And the Court of Appeals, just one of the smartest Maricopa County judges in this area, she practiced family law for years. She got reversed by the Court of Appeals. The Court of Appeals said, didn't you read the statute? And all of us, I mean, she's someone that all the rest of us judges look up to, and we're like, that's how we all read the statute, but I guess we read it wrong. So those are some areas where it has a big effect. The other area is in the area of orders of protection. Okay? If someone comes to me, they can come to me if I find that there's reasonable cause to believe that someone who has committed an act of domestic violence against them, or there's a reasonable likelihood that the person will commit an act of domestic violence against them, I can give them a protective order. There, I use the exact same definitions I'm using here. Okay? So, in the majority of the cases, female comes to me and said, the easy cases for me, female comes to me and says, yesterday, my boyfriend, my husband, got arrested for this criminal offense. Okay? Cops have found that there's reasonable cause, probable cause. Now, that isn't enough for me, but then she's going to be under oath, she's going to tell me, and I'm going to say, okay, I'm going to give you an order of protection. She gets out, it gets served, he's now subject to that order. One of the things is you can't possess a firearm if you're under an order of protection. And there's some other hoops. But he can come in and then ask for a hearing on it, where I hear both sides. Okay? The last one or two of those, I've granted the order, I've had a hearing, and I've vacated the order. Because it's amazing when you get both sides of the equation. The most egregious one I've had is the lady came to me and said, when we're exchanging our kids, he ran over my foot. Okay? That's an assault, probably an aggravated assault, because he used a car to do it. Okay? They have kids in common. I gave her the order. We have the full hearing. She forgot to tell me that this took place at one of the casino parking lots right there as you go in Fountain Hills. He said, she was blocking me in. I'm just trying to drive my car out. She may have stuck her foot out at the last minute. I don't know, but they called the police. The police came out, and she forgot to mention that she was the one that went to jail for inciting the situation, and after investigating, the police found that he wasn't going to jail. So those happen. Now there are some of those though. One of the first things.
We have three different ways.
Right.
Providing orders of protection against the same guy.
Right. Now, one of the things I will ask the people is, have you reported this to the police? Okay. That's not a prerequisite for me to give them an order of protection. I don't believe it's my role to say, sir, ma'am, I think you need to go report this to the police. Or, if you don't report it to the police, I'm not going to give you an order. Ultimately, that's the executive branch. Okay, that's where I think my job is to take the cases in front of me. It's a fine line. If people need help filling out a form, some of the clerks can help them. Here's a form. But even that, it gets close, because if you hand them a form that says ask for this, then you're sort of like leaning like, ask for this. You shouldn't be doing that. So the question, how do those women or men report? And I can tell you probably the reporting numbers are higher statistically. Women report more on average. They're more often the victim, but the men that are the victim, statistically I think report less. Because there's stigma on the women's side reporting, there's even more stigma on the men's side reporting. I think it's better than it used to be. It's a social problem. It's not going to be helped in the courts. One of the things that I think may help that, at least on the orders of protection, used to be, as of December 31st, if you wanted an order of protection, you filled out all the paperwork, you went to the clerk, you filed it at the clerk, you then came in, you saw a judge, and usually someone comes in, we get them in that day. And you can get an order anywhere you want. If I think my wife committed an act of domestic violence against me, I can drive down to Benson in southern Arizona and go to the Benson Magistrate Court and get an order of protection against my wife up here. You can get anywhere in the state you want. Now, the reason why is we want people to be able to get those if they need them. If they ran to mom or dad's house, we don't want them to have to go, oh, you gotta go back. Okay? So then they have that, goes from there. As of January 1st, there's now an online portal where on your phone, at home, at a shelter with a counselor, you can fill out all the paperwork ahead of time. There's not really paperwork. You can fill out the application ahead of time, and then you can make whatever arrangements you need to safely escape the situation, if it's a serious situation. And then you go, they give you a number, and then you walk up to the clerk and you say, here's my number. And the clerk then can type in that number into the statewide system. It pulls up your application. You can see a judge, and the judge will determine whether to give that, whether to grant that. So the idea is we want people to be able to fill these out in private. That website, if you're on the website filling it out and you hit whatever the magic key is, it goes to growing tomatoes in Montana or whatever that is. Okay? Because these are dangerous, many times these are very dangerous situations. Now, that whole system, great idea. The legislature passed it, I think, 2 years ago. The courts have been struggling to try to figure out how to implement it. We went live January 1st. I've done one of them. It was a horrible experience procedurally. The lady was entitled to an order. We gave her an order, but as far as getting it through the system, it took us an extra half an hour, 45 minutes.
Aren't the courts now supposed to guarantee delivery of that order of protection out to as of January 1st?
The other thing we would do is we would say, Shirley comes in to get her order of protection. I say, yes, Shirley, you get an order of protection. Here it is. And it's effective as soon as Shirley gets it served on whoever is on. So now, typically, she would then go to the constable's office, give it to the constable, and then the constable would try to get it served. The way it works now is it goes into the court system. We look down, and Shirley says the address of the person she's getting the order on is someone who lives in Flagstaff, so it gets electronically routed to the Flagstaff Police Department, and then the Flagstaff Police Department can serve it. But we used to say to whoever came in, I know you're probably scared to death to get this order, here it is, go to a different spot to get it served. So when it gets moved, I think it will be, once we work out all the bugs, it's going to be a lot better. But it's a little rough right now. Okay, just a second. Shirley, you've already asked the question. I'm going to go to Kathy, and then I'll go. And when I'm out of time, you just shut me down.
Okay, my question is, not an order of protection, but the woman has been severely injured or whatever, and the perpetrator, or whatever you call him, has been arrested. How far can it go through the system before she says, wait a minute, I need him for support, I don't want to file this? How long does she have?
The answer is no.
No.
Okay? I'll answer that more. So in Arizona, victims don't get to decide whether cases are filed. They don't charge crimes. Victim calls, typically, or law enforcement or neighbor, they see something happening. The law enforcement officer is going to make an initial decision right there what to do. The victim can be saying, please don't take him to jail, don't do this, and the cop thinks, I'm doing it, it's what needs to happen. They can do that. The victim can be saying, please take him to jail, and the officer's saying, I don't have enough to do it. The officer won't make that decision. Now, then there's another layer, which then the county attorney's office or the city prosecutor is going to review it. If it's a felony, it's going to go to a grand jury or a preliminary hearing. So let's say that the victim, male or female, and I use female just because statistically that's the numbers. Okay, it happens both ways. But let's say she at the scene, she just said, I'm beat up. She's going to the hospital. They take him to jail. As a victim in the case, she has victim's rights. One of the things is to fill out an impact statement. She has a right to appear at any hearings where he has a right to appear. She has a right to provide her input. She has a right to provide her input as to any plea agreement. She has a right to provide her input at sentencing. But she can be saying, don't prosecute him, don't prosecute him, don't prosecute him. And the county attorney's office or the town prosecutor can say, we're prosecuting him. I've heard, this is not my statement, but I've heard our county attorney, Mr. Beauchamp, say he believes it's his duty to prosecute those cases because he protects not only that victim, but other victims. I think that's his statement, not mine. And I think that's what Michelle was asking about when there's one perpetrator and potential multiple victims. But ultimately, and this is where the prosecutor, and all this process, when it comes to me, how it's charged, how it's pled, really severely ties my hands. Okay? And so, or what a jury decides. I mean, again, I don't get to, I had a recent sentencing, it's been in the paper, but there was some folks that seemed to indicate, Judge, we want you to correct what the jury did, okay? I don't do that, okay? I believe that the trial was conducted fairly. I made proper rulings. Now, Court of Appeals will tell me whether I did or not. But at the end of the day, the jury said the defendant is guilty of this. And then I made some findings. He had a right to have a jury determine whether he had priors and stuff, but he said I could do that. I made a determination. He had 2 priors. And then I said within that, what am I going to do? I'm not going to say the jury blew it. I'm going to try to make up for it. That one I gave him the aggravated maximum, not because the jury blew it, just because that was appropriate given all the circumstances in the case. So the answer is no, the victim has a right to participate, but they ultimately don't have control. And I'll see that sometimes where victims, they can get hostile towards the prosecutor because of the outcome of the case, either because they think it's being dealt too lightly or too harshly. And sometimes the prosecutors, I've had cases where I've said to the prosecutor, this seems like a really, really sweet deal for this offense. But I said, I was a prosecutor, I know the realities. They're looking at what they can get at trial. What witnesses are going to say what evidence is going to come in. I said, is this all the justice you think we can get from this case? And they said, this is the best we think we can get. So, okay.
Back to the bullying question. There's a case that took place at Payson High School where an autistic guy was bullied by somebody else. I don't know if one or many. I don't know if any touching took place at all, but the bullied person apparently said something that triggered an arrest. And so he's been in jail now since September. Basically, he's the victim responding as he can to a bullying situation. I understand the high school says there's no such thing as bullying.
Bullying is not a legal term, and it's one of those terms that I think if you go back and you say, what did it mean 25 years ago? What does it mean 20 years ago? What does it mean today? I think that's a sliding definition, and I think you're right. When I was in high school, that was the thing, which grown-ups would tell, sticks and stones will break my bones, words will never hurt you, and all of us kids were going, are you really that dumb? Because we're all going, I'd rather have somebody hit me than like shun me.
Get it over.
So those kind of cases, I generally said words don't get you in trouble. If I say, Kathy, I'm going to burn down your house, okay? If it's a real threat, threats are a crime. Okay? If I say I'm going to go shoot up the school, that's a threat. It could be there's some terrorism. I mean, there's some specific statutes. I think I know the case you're talking about. And they charged him, grand jury indicted him on some, I want to say some class 2 or 3 felonies that are very, very serious. I don't recall, I think the case is still pending. And those are one of those ones where ultimately we have 3 branches of government, and hopefully between the 3 of us, we can get it right. The legislature is saying, here's the parameters. The executive branch is saying, we're going to implement it, and the law and the judiciary has to say we operate within those rules. I mean, best example I had a guy in front of me convicted of aggravated DUI, mandatory prison. He's at home on hospice. Okay, the legislature said if you're convicted of he also had a prior felony. If you're convicted of a felony with a prior felony, you go to prison. Okay, he didn't show up. He showed up, testified, and then went back home. He's in hospice. I said, I understand he's in hospice. Law says I have to give him prison. I said. He gets X number of years in prison. He's not here. I'm going to issue a warrant for his arrest. It's up to the jail, the police department, or the sheriff's office to figure out whether they're going to go execute that warrant. I don't think they did right away, probably just selfishly because they didn't want to pay for his medical care.
Well, yeah.
But that's where I didn't have, the legislature said these are the parameters. As a judge, I said I follow those parameters, but the executive branch, they have discretion on how they do that. And ultimately, if you don't like what they do, the head of the executive branch at the federal level is the president, everybody down. At the county level, it's Sheriff Shepard. The state level, it's Governor Ducey. If you don't like those people, they're subject to your whims every 4 years. And that's so there. Okay, Shirley, I'll go to you, and then I'll come over, and hopefully I'm not out of time.
Okay, yeah, I'm watching my clock. All right, so severe orders of protection are the AKA red flag laws.
Okay.
Now, it's sounding to me like you have been doing orders of protection for years. So what is the difference between, from what I'm understanding, is someone can make a complaint and it doesn't go to the judge to get a order of protection. The police can just go take somebody and take their guns out of their house and put them in a 72-hour psych hold or whatever, and they're not getting any due process. So what's your thinking on that?
I'm not going to give you my political position on it, because I
Okay.
won't. Okay? But typically,
Pros and cons.
there was one, last year in Arizona, there was one floated, and was it SAFER? I don't remember, it had sort of a cool name. It was an acronym, okay? My understanding was it was basically the same process as an order of protection, except instead of my spouse or someone on that list committing an act of domestic violence or likely to, it's my neighbor, I see in his garage, it looks like he's got a lab, and he says, I got some C4 in here, and I've been playing with it, and I think I'm going to go use it at the school, and no. Normally, we don't punish, this isn't, what's the Tom Cruise movie where they were punishing people before they did the crimes.
Yeah.
Okay, we don't do that, but these kind of laws, the idea, I think, behind them is we think there's someone who has some severe, either mental or physiological dementia, those kind of things, and because of that, they're going to do something crazy. Now, what that crazy means. Yeah, not as much even a terrorist, but most of them are designed for mental health issues. I think my neighbor is mentally unsound. I believe he has a gun. I believe he has explosives. I think he's going to hurt somebody. I go to the court. Well, typically the officers would go to the court and get an order, and then it's an ex parte order, which means without just one side. They get the order, and then they take all the guns or whatever, and then that person can ask for a hearing.
So they don't go and talk to the guy first to see if it's just all a hoax perpetrated by the other neighbor?
That would be, most police departments probably would.
I would
think so. Again, that's the executive branch. You'd have to talk to your officers. And a lot of it depends on how the law is written. Arizona doesn't have one. There was one floated last year. It didn't go anywhere. I saw an article in the last couple of days. Colorado, they've been following it in a couple of counties in Colorado, I think, that have it. And a judge just reversed or denied one of them for the first time. Now, the first time out of there's only 3 or 4 since January 1st. But we do a similar thing today in the domestic violence context, that what those generally are there. The danger always in things like that is my neighbor doesn't like me, my neighbor makes it up, and that happens. Now, again, hopefully you can have, most of those have a pretty quick turnaround. If I give an order of protection, if I give the one party exclusive use of the house, they have a right to a hearing. I think it's within 5 days. It's pretty quick. If it's not exclusive use of the house, generally it's within 10 days they get the order. So it's a quick turnaround. Whenever we're taking people's rights away without having them be there, we try to do it really quick. When people come to me, I have people in the family law context that say, I want temporary orders without notice because. Now they come to me and say, I want temporary orders without notice because the kid's father was arrested for selling methamphetamine yesterday, and he has 2 priors, and he was also high at the time he had the kids for his visitation. You know what, I'll probably grant that temporary order without notice, but I'm going to set a hearing on it in 3 or 4 or 5 days because I want to hear the other side. Now, a lot of times those cases, they're so extreme that, yeah, and here's the police report. So it's not just that person, there's some backup for it. So, I'm going to go over here first, the patient.
This is a little off topic. The tragedy that happened in Tonto Basin a couple weeks ago with the children being dumped into the river.
Okay.
I guess they're thinking of charging the father. I guess it's with the DA right now, without stepping out anywhere. What are your thoughts on that?
I'll tell you the process of what's going to happen is most likely the sheriff's office will prepare reports. They'll submit them probably to the county attorney's office. The county attorney's office will make an initial determination whether they think it's something they should submit to the grand jury. And then the grand jury would hear it, and the grand jury would make a determination whether they choose to indict or not indict. And then that's how the process starts. Now, those offenses, if they were charged, they could be charged as domestic violence offenses, because it's probably going to be endangerment or negligent homicide or manslaughter, one of those type of things. And you look at the relationship that they're going to charge someone if, I don't know, it would be a father and kids. I mean, I only know what's in the news reports, that's all I know. And it appears that there was either a blood relation, an adopted relation, or something there.
Uncle, father, and then a couple of them were
Nieces and nephews, and that's where you're going to have to go back and see if nieces and nephews fall in the list. At some point, you get far enough out where they're outside that circle. If you get like I can tell you for sure a second cousin is not a domestic violence offense. Now, you might find if they've been living with you for 2 years, that you've resided together, that works. But that's ultimately, that's something, as courts, we don't stay out of, we stay out of what's charging decisions. If the other thing they can do, instead of submitting it to the grand jury, they can file it and then ask for a preliminary hearing. If they do that, either the justice of the peace or the judge, the Superior Court judge, will rule on whether there's probable cause to move forward. I've done a couple of those. I did one of those, in very few of them. I did one in St. John's for them on a murder case. I did one on Mr. Wright. We had a preliminary hearing. And I think there's one that they submitted on the record with some documents case, and there's maybe one other one. But most of the time, they go to grand jury. Okay, do I have time for another question?
Yeah, last question.
Last question.
Okay.
If there is elder abuse law in Arizona, how does it work with domestic violence or type charges?
One of the, go back to mine. This one. One of the crimes could be either child abuse or adult abuse. And basically, think of the adult abuse and the child abuse statute, it's the same statute. It's 1336.23. And so you commit it by either doing it basically against the kid or against someone who's elderly and is almost in the same vulnerable position.
Well, I noticed on here that a lot of times elder abuse involves financial crimes.
So then you're going to have to go down the left side, and if it's straight up theft or fraud, it's probably not going to be a domestic violence offense. Okay? So the moral of the story is I can cheat my mom out of all her money. I may be a crook, it may be a class 2 felony. I may go to prison on a class 2 felony, but I won't have a domestic violence allegation. Well, that's one of those things, do I really care? Probably not in that situation, because I guess I save $50 for the one fee and $50 for the other fee, and I don't have to do the classes. If it's a felony, I'm going to be a prohibited possessor no matter what. It's going to be way harder than if I was on probation for misdemeanor.
Just curious, because I think it's in California, there's specific elder abuse legislative laws.
Yeah, and there is. If you look at 1336.23, it's right there. It basically talks about kids. We always think about it as child abuse, but you can do the same thing to elders. And I suspect, number one, I don't think there's quite as many on the elder side.
It's not reported as...
And secondly, it's not reported or discovered. I had a case where a guy basically locked, it was a scene out of a movie. A guy locked his mom in her room was the allegation. And they found out because she got the window cracked open and was screaming and the neighbor called the police. That's what the allegations and the charges. So now, that's just the charges. But those kind of situations are reported occasionally. More often than not, it's the kids who get abused because I think generally it's easier to abuse someone who's smaller than you. Even if an elderly folk is not as fit or whatever, it's still just tempting to keep abusing kids.
Thank you.
Okay?
Okay.
Thanks.
Yay!